as the date of this complaint, Migos has prevailed at the trial court level in reforming the operation agreement and is in the process of defending that victory on appeal, of which has cost many thousands of dollars in legal fees. So then poor Migos, who didn't draft the agreement, got sued by the person that was like, hey, it's me and you, buddy. We're exclusive. Why are you seeing all these other people? And Migos was like, well, I thought I told you we were seeing other people, that we weren't exclusive. Welcome back to Wine and Chill, your home for all things entertainment, law, tea, and millennial adulting. I'm Stephanie, and today we are officially kicking off our entertainment law shenanigans, entertainment law scams and shams series. Let me know in the comments what we should call it. So, jazzing up our regularly scheduled disclaimer, by watching this video, you acknowledge that you have fully read the disclaimer that's below in the description box, and acknowledge that this video is for entertainment purposes only and should not serve as a substitute for legal advice from an attorney that you consult on your own. I'd like to say a huge shout out to my friend Jasmine for doing the legal research for me. She compiled the documents, and since we are going to review a pending lawsuit, which is all public information, I will link that down below. It's all online, so you can actually follow along. So we're starting today with Migos' lawsuit of their attorney. The reason why I wanted to start with this, A, it happened just a couple weeks ago, but B, the first thing I told y'all when we reviewed Kanye's contract is you need to get an attorney that's not affiliated with the record label. And when you do not, things like this happen. So let's hop right into it. So since we are not reviewing a contract today, we're actually reviewing a lawsuit. I'll just walk you through 30-second spiel of civil procedure. That way you can follow along the timeline of a lawsuit. My Civ Pro professor would be very proud that I remember all of this, because I'm a transactional attorney. I don't work in litigation. How it works, when you go to sue somebody, you file a complaint in the court of your choosing. Here, Migos chose the Superior Court of California, County of Los Angeles Central District. So you're gonna file a complaint, which basically is going to recite all the facts. It's going to lay out all the claims that you're alleging, and then the defendant will then have a certain amount of time to respond, and then that's called a response. And then you get to discovery, which is where basically the nosy busybodies pull up all the information that relate to your claim. And from there, then you have motions, and then eventually you'll likely either get to a settlement or you will get to a trial. I think it's about 90% of cases never get to trial. Most cases settle. This will likely settle, but if it goes to trial, that'll be very interesting to see. So as usual, I'm going to put the screenshots right here so you can read along, and with this you can always click down below in the description and read along there as well, whichever you'd like. Let's set the stage. And so when you're reading the complaint, you know how this is set up. So first you're going to have the introduction, which is basically the why are they suing this person, and then importantly, who the heck is this person, the parties. So once you get to page 4, you'll see that everything is numbered. Those, you refer to them as paragraphs. So paragraph 11 then starts to lay out everybody. Everyone's government is in here. You cannot sue somebody and use your performance name. Specifically, who are they suing? So they are suing their longtime attorney, Damian Granderson, and the law firm he worked for. So just for context, these at this point are all allegations. These are the facts as the Migos attorney, their new attorney, sees it. We are going to start it off here. What the heck are they suing for? So this action arises out of that timeless tale about the world-famous music group who was robbed and cheated out of millions of dollars by those individuals who the group hired to look out for its members' best interests. Defendant Damian Granderson is the personification of a self-absorbed shyster lawyer who saw his client as a mechanism to get rich by any means necessary, including at his client's expense. Like many musicians, the multi-award-winning hip-hop trio Migos had no formal training in law, accounting, finance, or business management. As such, Migos retained and relied on attorney Granderson to act as their fiduciary and use his expertise and best judgment to make decisions that were in Migos and each other group's best interest in all areas related to his retention. Granderson abused his position of Migos Trust as Migos fiduciary from the moment he was retained as Migos lawyer. Granderson was working with Migos since the group's early days, including etc., etc. So, with greed in his mind, Granderson saw the trio as easy targets to coax into one-sided deals that benefited Granderson and Granderson's higher priority client, Quality Control Music. So, this is very interesting, and I want to just point it out for 2 seconds. The language used in complaints is written in plain English, albeit it's kind of saucy. It reads as a soap opera. Very much different compared to the contracts that we looked over before, which are completely in legalese. This is to show you that A, attorneys can write in plain English when we want to. They just don't in contracts, which is trifling. And B, complaints are written as a story because they're supposed to be persuasive. They are sending this to the judge. They want the judge from the beginning to be on their side, to sympathize with them, to be like, yeah, this is trifling. Like, what is going on? So that's something to point out. And basically, the gist of why they're suing, Granderson, their attorney, also represents QCM, Quality Control Music, which is the record label they are assigned to. And we're going to go through all the allegations, which basically stem from the Migos claiming that their attorney sided with the record label, entered into deals against Migos' behalf, and that were more beneficial to the record label. And also, they're accusing him of malpractice. We're going to get into all 7 claims. So there's 7 claims in here. So that is our starting point. Okay. So there are 7 causes of action here. Causes of actions are the claims. That's basically what they're alleging. So the 7 causes of actions are professional malpractice. It is malpractice for you to represent both sides without getting a waiver for conflict of interest. And certain things you can't waive the conflict of interest, which we're going to get into. Breach of fiduciary duty. Then we have 3 specific California violations for professional code of business. Unjust enrichment, which we'll get into what that is specifically, and declaratory relief, which is them saying, hey, we are right, just give us this money, I'm over it. So one of the claims, and actually what I think is one of the most interesting parts of their claims of action is they're claiming malpractice. So they're claiming that their former attorney is incompetent. Their words, not mine. We're going to read into this. So we're going to go to paragraph 6, which is on page 3. Granderson once again favored QCM, so it's quality control, over Migos when negotiating co-publishing agreements. For example, a May 2018 amendment to Quavo's co-publishing agreement with Universal Music Publishing Group gave better terms to QCM than Quavo's original publishing agreement, which was negotiated when Quavo was not as big of a star and had less leverage. Further, when it came time to negotiate agreements for Migos and or the group's individual members, Granderson performed incompetently. For example, Granderson erroneously drafted an operating agreement with one of Migos' merchandising partners to say that the jointly owned entity would obtain a perpetual exclusive license to make certain Migos branded merchandise, rather than a non-exclusive license. So we're going to stop there. Incompetence is not a word used lightly. Throughout this entire complaint, you're going to see they're basically calling this attorney out and saying, you did this, you did this, you did this, all this is wrong, why would you do that? Aside from the glaring conflict of interest, Granderson also was careless and negligent in performing work on certain agreements he negotiated for plaintiffs. For instance, Granderson carelessly drafted an operating agreement. The purpose of the operating agreement was to allow for Design Studio 11 LLC to distribute certain Migos branded merchandise on non-exclusive basis, and for Design Studio and Migos to share in profits of that venture as co-members. Rather than draft the agreement the parties included, Granderson drafted the operating agreement in such a way to provide wire and effectively was granted a perpetual, here goes a perpetual again, exclusive license to distribute Migos branded merchandise. Perpetuity means forever. Exclusive means it's just you and that person. Non-exclusive means you can see other people. In the context of business relationship, you should definitely want to see other people. Granderson then negotiated to have Migos enter into a licensing agreement with Bravado International Group Merchandising Services that granted, I'm going to skip around the dates because it's irrelevant, that granted Bravado rights to sell merchandise that overlapped with the rights erroneously granted to Design Studio LLC. So basically what they're saying is their attorney drafted them this agreement when it should have been non-exclusive, because of course with merchandising rights, you want whoever has the best price should be the winner. So if so-and-so sells hats for 9 cents and the other person sells hats for 7 cents, obviously you want to make more profit. You're going with the person that makes the hats for 7 cents, same quality, what's the difference? And then you want, somebody else to make the shirts and whatever have you. By saying that the license was perpetual and exclusive, they were stuck with Design Studio. They then allege that the attorney went and found another merchandising company and was like, oh yeah, let's enter into agreement too. That's not how exclusivity works. Exclusive means me and you till death do us part. We are exclusive. This is why I'll get into arguments with people, not understanding what exclusivity means. We are exclusive, so that means ain't nobody else. You can't enter into these other contracts. By entering into these other contracts, then Migos got sued by the person they were supposed to be exclusive with. As the date of this complaint, Migos has prevailed at the trial court level in reforming the operation agreement and is in the process of defending that victory on appeal, of which has cost many thousands of dollars in legal fees. So then poor Migos, who didn't draft the agreement, got sued by the person that was like, hey, it's me and you, buddy. We're exclusive. Why are you seeing all these other people? And Migos was like, well, I thought I told you we were seeing other people, that we weren't exclusive. And they, of course, you know what receipts are for? Pull up the contract. It's whatever's in the contract. So you have to have a good attorney that does their job properly and that knows what they're doing. You can't assign rights that you don't have. So they're saying him doing that is a proof of incompetence. And between me, you, and YouTube, I wouldn't have done that. So let's put it this way. If I did that at work, I would probably get fired. So it is just to tell you how big of an error that is. What is going to happen when they get to the discovery phase? They are going to then release in the court documents all of these agreements. We're going to get to the part where they list out all the agreements he messed up. The list is very long. Also, this is quite uncomfortable for him to just have his business out there. Remember, these are allegations. These are very strongly worded allegations. The kicker with the malpractice claim of action, to be honest, in my opinion, is in paragraph 8. To add to the list of his numerous negligent acts, Granderson had the complete gall and audacity to practice law without a California license for 5 years after he moved to Los Angeles and began practicing law from his Beverly Hills hotel. Whew! The new Migos attorneys basically said the unmitigated gall of this man, because A, unlicensed practice of law is a crime. B, them putting that allegation in here is basically them also calling for his disbarment. If you get disbarred, that means you cannot practice law in that state. It's a serious allegation. So, that being said, let's talk about conflict of interest. The conflict of interest points basically tie into the unjust enrichment action as well as the malpractice claim of action. We're going to get into unjust enrichment because that's a very specific claim, so that way we can talk about that. So the text of this artist amendment strongly supports that Granderson assumed this dual representation, even though Granderson never provided Migos with a written fee agreement or conflict waiver. In particular, the artist amendment contains an acknowledgement regarding the right to independent counsel, which strongly implies, just as Granderson indicated orally, that Granderson was representing both QCM and Migos in connection with the suite of agreements, so he was not any party's independent counsel. So basically here, if you have a conflict of interest, that means the attorney is representing two different sides. It does happen occasionally. However, you're supposed to tell the clients, both clients, and then have them sign a waiver. Certain conflicts you cannot waive, which they then allege, even had he asked for a waiver, which he didn't, that's what their allegation, that he couldn't have waived this. So that is a huge issue, which is why I'm going to keep saying, if you're an artist, you have to get an attorney that's not affiliated with the record label. With the conflict of interest, the claim then from Migos' new litigation attorneys basically states out the more than a dozen agreements in which their former attorney was basically representing both QCM and Migos, which is a huge issue. They're all listed here. So basically what will happen if this gets to the discovery phase, all of those agreements will then be entered to the court so the court can review them, and those will be included as exhibits. So they will be exhibits A through O if this were to ever go to trial. So to back up, one of the main claims in this entire claim is that the attorney Granderson entered into an agreement behind Migos' back between QCM and Capitol Records for Capitol Records to be the sole distributor of all QCM artists' music, which includes Migos, which was to Migos' detriment. The distributor they had before was giving them a more fair split than Capitol Records was going to give them. Here we go. In fact, the nature of the conflict was not merely that QCM and Migos were counterparties to the artist amendment, but also, among other things, that A, QCM was earning enormous sums of undisclosed profits from this side deal with Capitol Records to make Capitol its exclusive distributor, and B, the QCM Migos agreement was subject to an extension favorable to QCM upon the extension of the distribution agreement with Capitol Records. Undisclosed sums of money, nothing good comes from undisclosed sums of money. Not only that, Granderson negotiated an amendment to Quavo's co-publishing agreement with Universal Music Publishing Group that was less favorable for Quavo and more favorable for QCM than the original co-publishing agreement. That made no sense because Quavo had more leverage in the second negotiation and can be explained only by references to Granderson's gross conflict of interest. Basically, back to the point that I made when we talked about the Kanye contract, when you make an amendment, if they entered into the agreement, so then here comes Granderson saying like, hey, let's like renegotiate that. We're gonna get a better price for you, whatever he told him. They are not saying, basically the new agreement they got was less favorable for Quavo, which didn't make sense because after this he had become a reputable star. He had become somebody with leverage, somebody whose name carried. So why would he then be entering into a deal that was against his detriment? The new attorney is claiming it's because Granderson negotiated strongly for QCM and not for Quavo, which is why you can't have an attorney and you shouldn't have an attorney that is representing both sides. All right, so there are 7 causes of action. And basically the way it works, we went through like the recitation of facts. They laid out like, this is Fugazi, this is Fugazi, this is Fugazi. And then you have the legalese is going to come in. So you're going to have the attorneys then tying in the statute of the law that they're trying to say like, hey, this is violated, this is why we're suing, with the facts. We're going to talk about unjust enrichment. Malpractice and the unjust enrichment, in my opinion, are the most interesting claims in here. Unjust enrichment is basically legalese for getting money that you didn't deserve, that you are unjustly enriched for, stealing, thievery, thief in other people's money. That's what it means. So on, where are we here? On page 20, so paragraph 82 is going to list out the unjust enrichment clauses. So basically, they're going to tie in the definition of unjust enrichment and bring in the legal language. So basically, paragraph 84, defendants would not have received the unlawful benefit but for their wrongful conduct. 85, as a direct and proximate result of the foregoing unjust enrichment, plaintiffs were damaged far in excess of the minimum jurisdiction of this court and subject to proof at trial. And then so forth. So now you're going to get the legal language. It's going to be interesting to see this case. It's going to be interesting to see if we can get the response. Then we can go ahead and talk about the response as well. What generally happens, the defendant almost always just says, I deny unequivocally paragraphs 1 through 80. So it'll deny all the recitation of the facts. They'll then give their own facts. Nobody's going to admit to unlicensed practice of law. It's easy to pull up whether or not you're practicing law. Every state has a database. So that's how they know that information. They're like, well, we looked at the database. You're not in there. So that's malpractice. He'll likely say, A, I'm in there. Actually, maybe you looked wrong. Or B, he'll say, I wasn't practicing law. As an attorney, the lines of practicing law, if I go into court, I'm obviously practicing law. If I review a contract, I'm not necessarily practicing law. It depends. Like, it's up for interpretation, which is a very interesting nuance. That doesn't mean I'm about to go to California and try my luck. But the fact that he had a Beverly Hills office would lead to, he was likely practicing law. We are going to see. I'm not passing judgment, just giving facts and reading to the allegations that are here in this. Go ahead and pour yourself some more wine. Speaking of which, I have a new wine glass. I want to say a huge thank you to my best friend, Rachel. I don't know if you guys can see it. I did have it filled up and I may have drank most of it before this. But yeah, it says wine and chill. So how cute. So back to the malpractice, the double dealing. Here we have in paragraph 45, if the foregoing were not enough, they basically said, y'all see the scammery? It gets worse. If the foregoing were not enough, Granderson also engaged in conduct while representing QCM that directly and substantially harmed Migos. In particular, Granderson negotiated for QCM a May 28, 2018 agreement with Capitol Records that extended the term of those parties' exclusive label agreement. Pursuant to the exclusive label agreement and the amendment extending the same, QCM was required to have Capitol Records be the distributor for any music recordings for which QCM controlled the distribution rights. In other words, QCM made enormous sums of money from an exclusive label agreement with Capitol Records, and that arrangement inherently harmed Migos because A, it subjected Migos to an extension to the term of the QCM Migos agreement, thereby requiring Migos to continue paying excessive compensation to QCM. B, it created an obstacle to Migos contracting with any record label other than Capitol Records to distribute Migos' works. As a result of the extension that Granderson negotiated and from which the firm earns a 5% commission, Granderson effectively prevented his other client, Migos, from ever being free of paying excessive compensation to QCM, from ever being signed to any other record label, and from ever obtaining negotiating leverage to secure reasonable terms in connection with the redistribution of its musical recordings. That paragraph there is a very layman's term summary of what we talked about in Kanye's contract breakdown. When you enter into these agreements, what the attorney did was essentially sign their rights away and the distribution to Capitol Records. And he did so because he got 5% of the earnings from QCM. The record label has deeper pockets than the artist. Point blank, period. So it's always important to make sure that A, you have a reputable attorney, and then B, that these type of shenanigans are not happening behind your back, because this is completely wild. I'm super interested to see the response to this, because obviously the defendant, the attorney, is going to deny all of these claims, and it'll be interesting to see how he denies it and what he claims is the truth. Because again, this is Migos' state of facts. This is them saying, like, this is our complaint. It's literally called a complaint. This is what we're saying. It's meant to be persuasive. This is all the things they are alleging. These are all allegations, which will be very different from what the defendant, Granderson, and his law firm are saying. Just reading this, taking out face value, it's in the realm of possibility. Thank you guys for watching. We are going to do our series every Sunday, Entertainment Law Shenanigans. Don't forget to let me know in the comments, do you think we should do Entertainment Law Shenanigans or Entertainment Scams and Shams? Either sounds fine to me. It's all a hot mess. And if you haven't already, please go ahead and like and subscribe. And don't worry, I didn't forget about the other series that I promised you. I'm working on it. We're going to do an overview of basic contracts in entertainment that you guys were curious about. So 360 deals, an overview of royalties, things like that. So we're, instead of looking at entertainment gone wrong, we're gonna try be proactive. Let me know in the comments what you thought about our first lawsuit breakdown. And if you have any questions about this specific lawsuit, let me know in the comments. Happy to answer them. And then hopefully we will see the response from their attorney, their former attorney, because they fired him, their former attorney soon. And then we can walk through that as well.